all to be on a same page, right? So now what is this Insolvency 101 I'm trying to get you here? The basics of insolvency, and from where I start off, that is, what is insolvency? So what is insolvency? Insolvency is nothing but the inability to pay. So imagine a scenario where there is a corporate entity by name ABC Limited, right? And also imagine a creditor by name, let us take a real same, let us say ICICI Bank is a creditor which has given loan to this corporate entity. Now, this corporate entity, after a period of time, has failed to make payment to the ICICI Bank. So in this case, what you can see is a case of a default of payment. But will every default, does that mean the company is not in a position to pay? This is a question mark. So now what is an insolvency? Insolvency means where the company's existing revenues or the company's ability to pay has completely eroded and the company is not in a position to pay back what it has taken as a debt from its capital contributor. So that is a classic case of an insolvency. So now when there is an insolvency, how should the country respond? When you have seen the increase in prices of the basic essential commodities, we all respond in a pattern. So how do we respond when there is an insolvency? How should the government respond when there is an insolvency? And this is how, the answer to this how is the history. So in the year 1909 and in 1929, the pre-independence era, the British have introduced laws, the provincial insolvency laws, to handle individual insolvencies. So where an individual becomes insolvent, that is, an individual becomes unable to pay his or her debt to a bank or to any other person, how to handle such individuals was covered there. Later we have got the Companies Act. In 1913 we had the Companies Act. 1956 we had the Companies Act. What did this act speak about? They only say you're insolvent, okay, file for winding up. So the moment you are unable to pay, how is the government responding? The government is responding in a manner asking you to just shut down all your operations, sell away all your assets and go out of the business. That was the scenario. And then in 1985, what was the change? We have got an act called Sikh Industrial Companies Act. What is this act? This act is primarily for the purpose of revival. But of whom? Of industrial companies alone. So there was a schedule of industries which have been covered under this particular act. And the act, of course, the intent of the act is really good, to revive, to get the revival of all these industries and to ensure these industries turn solvent from being insolvent. But what was the glitch? The glitch was that at that point of time, the debtors, that is the people, the promoters who are responsible for the company to land into insolvency, were continuing to be in possession of that particular debtor even during the revival period. So in operations, how does SICA work? So in SICA, when you make an application, to a body called BIFR. So what is this BIFR? BIFR is Board for Industrial and Financial Restructuring. This BIFR will look into whether this company is, can we revive this company or not? And then they come up with certain restructuring strategies, which the debtor himself will propose to the BIFR, then the BIFR will discuss within itself, and after an investigation, it ensures whether that would be good or not. And this used to take fancy amount of time. And along with it, the moratorium also used to extend like anything, because of which the banks used to suffer like hell. And hence, there was a report in 1993 to analyze the implementation of SICA and also the effectiveness of the BIFR. And in this report, Mr. Omkar Goswami, he reported that, in the first page, it was very beautifully said that there are Sikh companies, there are Sikh industries, there are Sikh financial institutions, but there never is a Sikh promoter. So that is the culture of the country, where the promoters are making monies, but not the companies where the promoters have invested in. So what is the grassroots problem, right? So this is a dilemma till 2016, unless the Insolvency and Bankruptcy Code 2016 to address the issue of insolvency. So the code, which I've referred to as a code or as an IBC, the Insolvency and Bankruptcy Code 2016, introduced you with the three kinds of freedoms the businesses enjoy. Now, as individuals, we have freedom of speech, freedom of expression, we have freedom to assemble, and all other constitutional rights, right? But as a company, what do they have? They have firstly the freedom to start a business, to freedom of entry, correct. Second, freedom of operations or running a business. So if you can see, you can start off a business, you can continue a business. Till here, the ease of doing business is addressing everything. Government say we have we have ease of doing business, so you can start audio video. Sorry. So the company says you have ease of doing business. The country says that you have ease of doing business, wherein you can start doing businesses, correct? Wherein within a day we can incorporate companies for you. That's great. But after that, what's happening? You can operate the businesses. Even there, the licenses, registrations, there are certain hiccups, but still the country is trying to address it. All the states are trying to address the same. But next, the freedom of exit. What happens if something goes wrong? That is what is the dilemma. All the entrepreneurship, I don't know, they can take risk to an extent, but what happens if something goes drastically wrong? Can you take a decision so risky, but there is also an upside, but the downside is too bad? Can you take such decisions? The answer in India is definitely no. The reason is, what happens if I go completely wrong? Everyone come against me. Everyone will try to exploit me, or the company is gone. The company is liquidated. This was the fear. The business model used to be completely shattered away. Then how in the world should I solve this problem, right? So this freedom of exit, keep it in mind, to know, in order for you to digest the fact why IBC, the Insolvency and Bankruptcy Code, has come into picture. So now coming to the next important leg of Insolvency 101, which is creditor in control. So here, I'll just give a simple analogy for you to understand. A company is incorporated by the equity shareholders, but for a capital requirement of a company, we also rely on debt. So the capital contributor of a company are equity and debt. So what does the creditor tell to the equity shareholder? Creditor says, Mr. Equity Shareholder, unless and until the company is paying me monies, you are the boss. I owe you. Whatever you say, what are the decisions you take in the shareholders meeting will hold good. What are the decisions you take and to go forward with the company will hold good. But the moment the company turns into insolvency, sorry, that's not happening. Let me be the boss. That is what is the creditor in control, and that should how be a company has to be run. But was that the case under SICA? The answer is no. Under SICA, even after knowing that the company is insolvent, the equity shareholder is still the boss. But whereas under this code, it has addressed it in a very different manner. And now finally, coming to the concept of maximization of value of assets. Again, under 101, what we need to understand here is that where a company is not in a position to put the best use of its assets, it's always feasible and viable to transfer such assets to such applicant or to such person who can put such assets to the best use, or liquidate the assets, sell off the assets on a piecemeal basis and get back the money. So this is the funda, maximization of value of assets. Either increase the value of the assets by way of finding out someone who can actually do a turnaround of this or get the assets to the best use of them, or where there is no such possibility, liquidate the company. So this is the very basis of IBC. So now let me just tell you how the freedom of exit is being addressed under IBC. So where a company fails, now immediately creditor in control triggers. What is a creditor in control? What are they doing? They are trying to maximize the value of assets. So effectively, what are we doing? We are providing a regime where insolvency, the framework of insolvency, is being built from the roots. So from in the year 2015, we went to analyze the root cause of the problem the country is facing in terms of insolvency. The piling of NPAs, you get to see in the newspapers what's wrong with the NPAs. So why is the NPA running into lakhs and lakhs of crores? What is the reason? The reason is that where companies fail to make payment, they turn into insolvents. There is no common strategy available to restructure such company. The RBI, the governor, the ex-governor, Mr. Raghuram Rajan, he has introduced the concept of corporate debt restructuring, strategic debt restructuring, S4As. So where did all this go wrong? Because few didn't have the legal sanctity, few were not able to address the concerns of all the stakeholders. But now there is a need for a code or for an act or for basically for the government to respond to the situation, and the response is the Insolvency and Bankruptcy Code 2016. The four main objects of this code are: number one, time-bound resolution. So initially, as I said in Sika, they used to take their own sweet own time, but now it is time-bound. The timelines are stringent. Second, maximization of value of assets, as I already told you. Third, promotion of entrepreneurship. So the code itself specifies that their intention is to promote entrepreneurship, which is commendable. And next, the consequence of it, and the fourth main objective is to balance the interest of all the stakeholders. Unlike any other strategy, here you need to balance the interest of all the stakeholders, whoever are interested or involved in this particular of that particular corporate person. And then finally, availability of credit. So where there is a proper freedom of exit provided through a regulatory framework, the availability of credit automatically improves in the market, which also stimulates the credit culture in a country. So these are the objects of the IBC. So under the IBC, the since it is a code, why is it a code? Because it is getting all the insolvency related laws into one single code. That is why it's a code. So this addresses both the corporate persons as well as the individuals. But now in our presentation today, our entire focus will be only and solely on how we address the problem of insolvency of corporate. So this in this entire presentation, we will be addressing only on how we will be addressing the issue of corporate insolvency, right? So that is where the word has come, corporate insolvency resolution process. So our title, which we started the webinar one, which we have come up with, is corporate insolvency resolution process, step by step analysis of the procedures. So what is this corporate insolvency resolution process? So it is a process to resolve the insolvency position of a corporate. So if you reverse it, that's basically the meaning of a CIRP, a process to resolve the insolvency of corporate persons, right? So now in this webinar, I am going to tell you how we are going to address this issue of corporate insolvency resolution process. So I went to the subsequent slide. So I hope there is a change in the slide. So it takes 10 seconds. So it's just a buffer time. Maybe for you all also to relax. So sorry, in case you have any questions, please feel free to type it in the Q&A. And if at all it is something contextual to what we are discussing, I would try to address it then and there. But I plan that it is better to address all the queries at the fag end of the session, so wherein we can have a detailed discussion from every participant. So in case there is any question, our team here will immediately let me know, and I will definitely address the same. So please feel free to ask any question in the Q&A column, and we will revert for sure. Is it ready? Am I visible? No, no. Okay. I think the screen sharing has stopped. Still. Do you people get the second slide? Wait. I think I will start sharing it again. Is it okay now? Is it on? Are we ready? So I'm not visible now. No problem. Just before we proceed, can you just confirm that you're able to have a view of the slides, because Mr. Vikas opined. Am I audible? No. See, is muted. Hello, am I audible? Am I audible? Yeah, sure. Fine. So let's just start it off now. I think, yeah, right. Yeah. So just confirm if it is on. Sure. Fine. So now, with the kind of intro we had, and also the reasons for having a code to address the situation of insolvency the country is facing. Now, again, let us go back to the same visualization of the example of a company ABC Limited, which has taken loan from ICICI Bank, and now it failed to make the payment. So what actually happened? There was an occurrence of default. So under IBC, the stage 1 is nothing but occurrence of default, and the default is by a corporate entity. Under the code, such corporate entity, who did a default is referred to as a corporate debtor. So where a default has been occurred by a corporate debtor. So now when I say default, what is this default? This is the default which triggered the code, which triggered the applicability of this code. So can we say that every amount of default can lead a company into insolvency? The answer is no. So they have quantified this concept of default by saying that the amount of default, the minimum amount of default is rupees 1 lakh. So, as per section 4 of the Insolvency and Bankruptcy Code, it was clearly laid down that all the matters related to insolvency or the liquidation of a corporate debtor will be entertained only where the minimum amount of default is rupees 1 lakh. Now, okay, now that there is a default of 1 lakh, what happens next? So whenever there is any default of 1 lakh, where corporate debtor commits a default of, let us say, minimum of 1 lakh, he is committing that corporate debtor is committing such default either to a operational creditor or a financial creditor. So now what are these two kinds of creditors, financial, operational? So creditors, as we know, are the ones who give debt or monies to a corporate person. But now, where such creditor, the code says that, or rather, if I go back from the code to the previous, the BLRC or even the joint committee of the Lok Sabha, they opined unilaterally that the creditors can be only of two types. One, a financial creditor. Two, an operational creditor. Or three, any other creditor. It's so till date, such any other creditor has been very less. The reporting of such any other creditors has been really less. But when it comes to the two major kind of categories, the financial creditor and the operational creditor, who are they? The financial creditors are those who usually, you can see, the banks, financial institutions, or the loans, which you can say where the monies have been given for keeping in view the time value of money. So where the money has been lent to a corporate debtor, keeping in view the time value of money, such debt is categorized as financial debt, and such creditor who has given such financial debt to a corporate debtor is termed as a financial creditor. Coming to the operational creditor, as the name operational suggests, so these are the people who gave debt not in terms of the time value of money, but as part of the business. So as you know, there is something called as a working capital. So there are operational suppliers, there are customers who run on a credit basis. For example, I supply products to a corporate debtor. The corporate debtor enjoys a benefit of 45 days for the payment, which is the working capital. And the corporate debtor further sells it to its end user, where the end user enjoys a 50 days benefit. That might be that working capital or the leverage. So as and when the payments are made to the corporate debtor will pay the payment to the supplier. So this is how the working chain totally runs. So now that I have given monies, or let us say I have did my supplies of goods, or I rendered certain service to a corporate debtor or to a corporate debtor, and the corporate debtor owes me money which he didn't pay. In such situation, I will be an operational creditor and not a financial creditor, because the code do not want to categorize me on par with any financial creditor, because the financial creditor has given money keeping in view the time value of money, whereas an operational creditor does it as part of the business. So here, in case of operational creditor, the most important concept, that is operational debt, has arisen due to provision of supply of goods or provision of services. So if you look at section 6 of the code, it clearly states where there is any default committed, a financial creditor, an operational creditor, or a corporate debtor itself may initiate CIRP in respect of such corporate debtor. So now, to quickly summarize stage 1, what happens in case of occurrence of default? So where there is a default which has occurred, either the financial creditor to whom the such default has occurred, or an operational creditor, or the corporate debtor itself. So where the corporate debtor feels that, okay, I defaulted more than 1 lakh and I'm not in a position to repay, I am insolvent. In either of these three cases, whether the operational creditor or a financial creditor or a corporate debtor, these three can initiate CIRP. So the stage 1 is set. It basically talks about occurrence of default. So the moment default is occurred, IBC can be triggered. So in order for you to look into whether IBC can be triggered or not, you should look at the amount of default. It has to be minimum 1 lakh rupees. And number 2, who can trigger default? Who can trigger who can trigger the code? The person to whom such default has been made. And who can be such person? Such person can be a operational creditor or a financial creditor, or even the corporate debtor itself. Where a corporate debtor did a default, it can on its own initiate CIRP. So this is a stage 1. So any questions on stage 1? You can please post it on the Q&A. I'll just pause for a minute. So in case you have any questions, please post for Q&A. Sorry, is that it? Can the secretary initiate CIRP and cooperative has given guarantee transaction? The DND and compensation is mandated to. ठीक है. On the corporate debtor guarantor, no? Fine. So we have a query from Mr. Rohit Soni in terms of initiation of CIRP against the corporate guarantor. So now, Mr. Rohit, just to, because we are in stage 2, it's good that you have asked at the time of initiation, can we initiate against the corporate guarantor? Yes, I will address. The answer is yes. You can initiate against the corporate guarantor. The answer is definitely yes. But if you want to know the rationale or how it is done, we will discuss it at the end of the session. So for now, to address your concern, the answer is definitely yes. And that is the basic reason why now that, of course, corporate guarantors again you come under CIRP, but even if there is a personal, that is a promoter giving guarantee, even such the insolvency resolution process can be initiated against the promoter as well. So that is why the personal guarantor rules and the regulations have been introduced respectively by the central government and the IBBI. I hope this addresses your initial concern of can we initiate. About the NESL thing, we will address it at the end of the session, because that cannot be linked right now. I hope there are no further questions. Sorry, there is one more from Mr. Aditya Shah. How can the corporate? Yeah. So yes, Mr. Aditya, it's a good question. So let us try to spend a minute on this. So how can a corporate debtor initiate insolvency against itself? So now, let me tell you about the US scenario. So in the US, what happens in the US? So where you end up into insolvency, the promoter itself will take the company into a bankruptcy process, whereby it's popularly called as Chapter 11 bankruptcy, whereby the bankruptcy period whereby the bankruptcy is initiated, and the insolvency professionals in that country, that is the US, will try to come up with a strategy to revive the company. So over there, the debtor is going into a bankruptcy process to get out of this concept of insolvency. But now, Mr. Aditya, to answer, to address your question in a dramatic manner, in IBC, to be frank, there is no motivation for a promoter to take the corporate debtor into insolvency, for the simple reason that he is going to lose control over the company. So where a promoter is going to lose control over the company, since we are talking about creditor in possession model, and also a famous section 29A, which we'll be discussing in a subsequent slides. So there is basically no motivation for the promoter to take it and land it into insolvency. However, where the where the corporate debtors has facing insolvency, and the promoter knows it right from the beginning, and even before the company turning into a NPA, as a prudent basis, if a promoter wishes to land this company into insolvency, there is a provision made under the code whereby the creditor itself may initiate insolvency. So the procedure has also been specified under the code as to how a corporate debtor can initiate CIRP against itself. That is what we'll be discussing in stage 2 in terms of the CIRP. And yeah, I hope I have addressed your question. So if you are satisfied, Aditya, you can say that it addresses your concern. Can we go ahead, Mr. Aditya? इसमें cover करूँगा ना? You reply. Answer to all. Did you get a reply from Aditya? Okay, Aditya. Yeah, thank you, Aditya. So now let us go to stage 2, that is initiation of CRP. So the moment a default has occurred, the creditors, that is a financial creditor, operational creditor, or a corporate debtor, as we have seen under section 6 of the code, may initiate CRP. So now this slide will be addressing as to how can they initiate CRP. So now from now on, we are going from substantial concepts into the procedural aspects, right? So if you can see here, in a CRP, the initiation can be made by a financial creditor. So let me just talk about the financial creditor now. So what happens in the case of a financial creditor? It is famously called a Section 7 application. So Section 7 of the code deals with how a financial creditor can file for an application for initiation of CIRP against a corporate debtor. Section 7 read with Rule 4. And when I say a rule, here I am referring to the Insolvency and Bankruptcy Application to Adjudicating Authority Rules 2016. And wherever I refer to regulation, I'm referring to the Insolvency and Bankruptcy Board of India, Insolvency Resolution Process for Corporate Persons Regulations 2016. So now coming back to the financial creditor's point, so where a financial creditor, in our earlier example, ICICI Bank, which which has given loans to ABC Limited, and ABC Limited failed to make payment to the ICICI Bank, thereby amounting to default. Now ICICI Bank wishes to initiate CIRP against this financial creditor. How can it do? The procedure is quite simple. Such ICICI Bank shall pay an amount of rupees 25,000 along with Form 1, and such application shall be made, of course, in Form 1. The Form 1 contains all the basic details, saying that the name of the corporate debtor, address of the corporate debtor, what is the amount of default, and what is the occurrence of default, along with adequate documents which can substantiate your claim. So application in Form 1 shall be made by the financial creditor directly with the adjudicating authority. So now the concept of adjudicating authority. What is this concept of adjudicating authority? So in this code, to adjudicate whether or not this company has to be resolved or to be liquidated, there has to be certain law. There has to be certain order or an authority. So such authority has been named as an adjudicating authority because it adjudicates. So now who is this adjudicating authority under the code? It can be any. To be frank, whoever has been notified under the code, they can act as an adjudicating authority. Then who has been notified, right? So for the corporate persons, the National Company Law Tribunal is the adjudicating authority, whereas for individuals, the Debt Recovery Tribunal is the adjudicating authority. Not just for individuals, also for partnership firms which are unregistered or other partnership firms under the Partnership Act. When it comes to the limited liability partnerships or any other corporate entity, corporate persons, the National Company Law Tribunal shall be the appropriate forum, which is the adjudicating authority. So now a financial creditor, in order to initiate CIRP against a corporate debtor, shall make an application in Form 1 under Section 7 of the IBC. And now, along with making an application to the adjudicating authority, it shall also forward. Achut, just a minute. I'll just finish this. So it shall also forward the same application also to the corporate debtor at its registered office. Yeah, Achut, do you have something? You rose your hand. Can you type your question, Achut? Or maybe we can address it after the end of this stage, I believe. So what of the question you have? You just type it in the Q&A. I will be addressing it the moment I get done with this stage 2, right? So now, a financial creditor, right? So just to quickly again summarize, the financial creditor to initiate CIRP against a corporate debtor shall make an application in Form 1 along with requisite documents. So now, for a corporate debtor, so the operation creditor, there is certain procedure involved, so I'm parking it for a minute. So for a corporate debtor, how do I initiate CIRP? So now, as a corporate debtor, in fact, we have discussed this because of the query raised by Mr. Aditya, but still I would just repeat it in the interest of this flow of our presentation. So under Section 10, the corporate debtor itself can initiate CIRP against itself. Again, a disclaimer that there will be no motivation for the corporate debtor to come forward. However, where it's a genuine concern that the company is under the operational distress and there is no such kind of fraud or nothing involved in the company, and the corporate debtor wishes to exit the business, the promoter maybe you can say wishes to exit the business, but at the same time has an intention to leave the business to the market, for the market to decide whoever wants to use such a business to the best use, such persons, which is of course it is happening. It's not like no corporate debtor till now has filed for CIRP. There are many such cases. So they can file for initiation of CIRP against its own entity in Form 6. The application shall be made in Form 6, and the same kind of content, the name of the corporate debtor, and also the details of the default. So details of default include to whom you have made the default and what is the amount of default that also will be taken into consideration. This is in case of a corporate debtor. So now talking about an operational creditor. So what does an operational creditor do? Operational creditor, as I said earlier, is someone who has given, who supplied goods or has provided services, and as a matter of which the company failed to make payments to him, and effectively he has become an operational creditor. So now what happens in this case? So in this case, the applicable sections are Section 8 and Section 9 of the Insolvency and Bankruptcy Code, read with Rule 5 and 6. Okay, leaving this aside. So now what happens in case of an operational creditor? So I wish to have your attention flow of information. I hope it is visible. Is it? Okay. We'll just pause for a second here because it just takes time. It's taking some time to. Is it? Fine. So I hope it is visible now. The flow of the flow of information. The flow of the procedure. So where an operational creditor wants to initiate CIRP, the corporate insolvency resolution process, against a corporate debtor, what is the step 1? The step 1 here is not filing of application with the adjudicating authority. Rather, that is a last step. So what is the first step? Even before filing of application, firstly, you have to deliver a demand notice to the registered office of the corporate debtor. So what is this demand notice? It is nothing but notice demanding the payment of monies to the operational creditor. You can either deliver a demand notice in Form 3 or you can simply deliver a notice along with your invoices in Form 4, because invoices are also form of demand only. So where you can, where you want to establish a claim that there is certain monies from the company, firstly either you send a demand notice or you can also send demand notice in Form 3, or you can also send invoices along with notice specified in Form 4 of the rules. So now this will be sent to the registered office of the corporate debtor. Now, what is step 2? So now that the corporate debtor, assume the ABC Limited has received from, let us say, some XYZ supplier. So now this ABC Limited, within 10 days of the receipt of such demand notice, has to necessarily reply to such notice stating or rebutting to whatever be the claims made by the corporate debtor. So as and when there is any rebuttal of the claims made by the operational creditor, the corporate debtor has to substantiate the same. And in addition, the corporate debtor can demonstrate that there is a default which is incurred. So there is an existence of default, and where a corporate debtor establishes that there is an existence of default, the operational creditor now has to dispute that. So now what is the relevance of this existence of default? So to, this is covered in the next slide, but still to introduce this, the law provides that where there is an existence of default, the operational creditor has to first solve the default in the pending any existence of dispute. Sorry, I use the word default, it's actually dispute. So pending any existence of dispute, operational creditor cannot initiate CIRP against such corporate debtor. So this you put it in your mind. So where a corporate debtor establishes that this demand of, let us say, 10 lakhs from XYZ has already been under dispute. So I am disputing that there was no delivery of goods, rather I'm disputing that the quality is bad. So all of these are certain disputes because of which the amount is not yet being freezed. So such kind of lame claims cannot be taken by the operational creditor against the corporate debtor and initiate, and he can go for initiation of CIRP. So that was the intention. So under step 1 we deliver the demand notice, and the step 2 the corporate debtor will reply to your demand notice, and within 10 days of the receipt of such demand notice. And what is step 3? Step 3 is nothing but filing of application with the adjudicating authority. So where a corporate debtor has not replied to your notice, or is not, where he has acknowledged but he did not make any payments to you within the 10 days, or where he did not establish any dispute involved, or where he has made a claim that there is a dispute there but you rebut saying that there was no existence of dispute, in either of these cases you can file an application in form 5 as an operational creditor to initiate corporate insolvency resolution process against the corporate debtor. So to quickly summarize, step 1, send a demand notice. Step 2, the CD shall within 10 days of the receipt of such notice give its reply. And step 3, where the reply is not acknowledgement, that is there is no payment made, or there is no claim made of the existence of dispute, or where the existence of dispute, where the corporate debtor says that there is a dispute involved, but the operational creditor rebuts that, stating that no, there is no existence of default in either, existence of dispute in either of these 3 cases. The operational creditor may move before the adjudicating authority by way of filing form 5 for initiation of CIRP. So this is stage 2, which is initiation of CIRP. So now that we have covered 2 stages, the stage 1 is where a default has occurred. Stage 2, the moment default has occurred, how can someone initiate CIRP? So occurrence of default is something substantial, whereas this stage 2 is something which is completely procedural in nature. So now I will spend a fair bit of time on addressing this differentiation between financial creditor and an operational creditor. So you might feel that in case of a financial creditor, they are directly filing application in form 1. In case of an operational creditor, they can't do it. They should file for a demand notice, wait for the reply. In case there is an existence of dispute, they cannot initiate CIRP. Why these restrictions for an operational creditor? Why didn't you give such restrictions to a financial creditor? This was debated to an extent that it went to the Supreme Court, and finally in the landmark judgment of Swiss ribbons, the Supreme Court held that yes, the differentiation between financial creditor and operational creditor is justifiable, and they have quoted what the BLRC has also come up with. They have said that the financial creditors are the people who did the due diligence of the company, and hence they also know. I'm sorry, that's the later, I mean, that's all, polished part. But basically, the financial creditors are the ones who give loans through a section that is completely recorded. The records are available to establish that a loan has been given. The records are available to establish that a default has been made. But when it comes to operational creditor, such establishment of records is something which is very difficult. And hence, they have said that, giving a additional step for giving an opportunity for the corporate debtor to rebut such claims of the operational creditor is something which is very important, or else all the operational creditors might misuse CIRP, and that was the intention with which they have differentiated between how financial creditor has to be treated under the code and how operational creditor has to be treated under the code. So I hope I've conveyed the stage 2, the CIRP, the initiation of CIRP process. So any questions in this stage 2, you can raise it right away. I think we have a question now from Mr. Achut. Okay, hi Achut. How do we ask for a simple direction to opt for arbitration on the contract undersigned in the application stage? So Let me just read it again in the interest of everyone. So Mr. Achyut, who is pursuing his law, he has a question, which is, how do we ask for a simple direction in the application stage, that like to opt for arbitration under the contract undersigned, right? So now, Mr. Achyut, it's a good question. So, firstly, the reason why I said it a good question is that because it is a fundamental doubt which everyone should get. When there is an option of arbitration, or when you want to opt for arbitration or for such other kind of alternative dispute mechanisms, IBC is not the forum. Initially, IBC is not the forum to address the disputes. IBC is never to solve your disputes. IBC is a code, or IBC is a framework where recovery is not the agenda but resolution is the agenda. They want to address insolvency but not to address any disputes between two parties. So where an operational creditor is filing an application, and if he wants to opt for arbitration, to be arbitration, he cannot actually come under IBC, Mr. Rachar. So he should rather go out of IBC and do the arbitration part and only then come to the IBC. Under IBC, the adjudicating authority does not have any power to direct to the parties to go for arbitration, because it is beyond the scope of the adjudicating authority. So in the interest of everyone, let me clarify again that adjudicating authority under the IBC is not meant to adjudicate any other thing unless other than which is covered under the IBC. If you want to go for arbitration or if you want to file a civil claim, it is completely outside the IBC. But the moment you trigger IBC, the entire procedures test simply apply irrespective of what kind of company or under what sector you are, and also irrespective of whether you are undergoing arbitration or you are doing anything otherwise. But there is one important thing here, Achyut, to clarify you, that where you are already undergoing arbitration, in such cases the other party cannot initiate CIRP against you because there is an existence of dispute. Correct. So where there is an existence of dispute, such existence of dispute is nothing but where a case is pending under case is pending in arbitration, pending in civil courts, or where you have blatantly disputed it through your emails. Maybe under emails also, if there is a correspondence which justifies that you are not agreeing to the amount, or there is a earlier correspondence that there is a dispute between both the parties, need not necessarily be you under arbitration or under civil court or civil cases. Even in such cases, it is termed as existence of default. So this is also in detail covered in the case of Mobilox Innovations, where they have established that existence of dispute need not necessarily be that you are undergoing arbitration. It can be anything where before sending of the demand notice, where both the parties have a dispute over the kind of services you have provided, or the kind of damages you have done, or the kind of amount you want to claim from them. In either of the cases, existence of dispute will trigger and you cannot come under CIRP. So to answer your question in one single line, no, you cannot make a claim or application for asking the adjudicating authority to saying that we can opt for arbitration. If you want to opt for arbitration, you have to withdraw your application under the CIRP. Rather, you cannot even come under IBC, right? So any other questions in stage 2? So I take it as a no. So now let us go to stage 3, which is admission or rejection of application. So are we live? Are you people able to see stage 3? Yeah. So now admission or rejection of application, stage 3. And just in case anyone is not able to view it, please send it in the message so that I can wait for a while. I mean, at least wait for like 5-6 seconds so that we are all on the same page. Yeah, I hope, yeah, everyone is on. So now stage 3. So stage 1 is an occurrence of default. Stage 2 is initiation of CIRP. So now all the three parties at the end have filed their applications before the adjudicating authority, that is the NCLT. And depending upon the registered office of the corporate debtor, the jurisdiction of the NCLT will be decided. If your corporate office is somewhere in Hyderabad, it will be NCLT Hyderabad. If your corporate office is in Delhi, it is NCLT Delhi. Chennai, NCLT Chennai. Similarly, there are certain regions allotted. So such NCLT will have the jurisdiction to address such case. So now in case of so now that CIRP has initiated, either a form 1 has been filed or form 5 has been filed or form 6 has been filed by the respective parties before the NCLT, what will the NCLT look into? So this is quite interesting and I enjoy debating this a lot. There was one particular case, Unitech Green case, where Unigreen, I believe. So the case where the concept was that the company was undergoing the recovery proceedings in civil court. It was undergoing possession proceedings in under the SICA, and the creditors were behind that company for many years. So now all of a sudden, after the IBC has come, Mr. Aditya, I think you will be interested in this. The corporate debtor had taken itself into the CIRP. Now all the creditors, they are having hue and cry, because there are few creditors who are secured creditors who had security over the assets of the company, and now they are concerned for the reason that now everything starts afresh. Number one. Number two, their interest, previously it was one asset, you sell it, you get some money. Now you have to ensure that all the interests of all the stakeholders are protected, and only then you are also being considered. So is that valid? So what did the secured creditors say? They went to the NCLT stating that Honorable NCLT, this corporate debtor had malafide intentions to initiate CIRP against itself, and hence it has to be struck down. The basic intention is forum shopping, and number two, they want to delay the procedures. That was the plea. What did NCLT do? The NCLT rejected the application of admission and said that this application cannot be admitted on the fact that the corporate debtor is misusing IBC. Now, will the corporate debtor stop there? It goes to on an appeal. So on an appeal, so who is the appellate authority? Under the Insolvency and Bankruptcy Code, the appellate authority is the National Company Law Appellate Tribunal, which is NCLAT. So what did this NCLAT do? NCLAT said that was not happening. As a as an adjudicating authority, your role under the code is not intended to look into the intentions or any other aspects of any of the applicant. The only thing you have to look into is the facts and the merits. Even, to be frank, not the merits, but the facts and the evidence. So what are they, and how did they establish that? So now that is what I'm going to cover. So for an adjudicating authority, for that is the NCLT, even after the occurrence of default is done, where an application for initiation CIRP has been made, they can look into only 5 major conditions. If these conditions are met, the adjudicating authority will admit the application. If either of it is not met, the adjudicating authority will reject the application. So what are those conditions? The first 3 conditions are very important, because they are also being reiterated in the Innovative Industries Limited case by the Honorable Supreme Court, in which case even the Honorable NCLAT also opined that these 3 conditions are very important, and these 3 conditions are met, you can the adjudicating authority shall, there is no discretion available to adjudicating authority to reject on such cases. If these 3 conditions are met, the adjudicating authority shall admit such applications. These 3 conditions are predominantly for the operational as well as the financial creditors, and the condition number 1 and 5 are tagged. So what is condition number 1? Occurrence of default. What is condition number 5? Evidence of default. So evidence of such occurrence of default. So where there is a default occurred, where the applicant is able to prove that a default has been occurred, then condition number 1 is met, and condition number 5 is also met. So condition number 5 is your evidence of default, maybe certificate from a bank or a financial institution, certificate from a information utility. So information utility is again one institution which has been established under the code to provide information in terms of the debt maintained by the financial creditors or operational creditors of a corporate debt. So that or the default, any debt will be recorded at the same time the default also would be recorded. So that is one certificate you may ask for, or any other relevant document to prove your default. So where condition number 1 is proved, that is occurrence of default has been proved, it means condition number 5 is also met. Now, second thing the adjudicating authority will look into is whether the application is complete in all the respects, which means whether the application is completely filled, all the details have been provided or not, all the relevant documents required to substantiate the application have they been given or not. If this is being met, then condition 2 is also satisfied. Now coming to condition 3. Condition 3 talks about disciplinary proceedings against proposed insolvency resolution professional. So now let me introduce you the hero behind the Insolvency and Bankruptcy Code, that is a resolution professional or an interim resolution professional. So what is this concept of resolution professional? So earlier, as I told you, that under SICA there is something called as BIFR, Board for Industry industrial and financial restructuring. So now that was a government run body. There is bureaucracy involved in it, the long delays and all. So now that is gone. The entire concept of BIFR is gone. So then what difference did they do? They basically looked into the world around, how the insolvency framework of the rest of the world is functioning in the UK, in US, in New Zealand, in Australia. What is happening, what was happening, and why are they very successful in terms of implementation of their insolvency framework? The reason is they have like the best of the professionals working exclusively on resolving such debt or stressed assets, and they are termed as insolvency practitioners, insolvency professionals, and they are used interchangeably. So India has also adopted a similar kind of a framework where a company, when defaults and it goes into insolvency, it has to appoint a interim resolution professional who will take the role of the management. To be frank, the moment the insolvency is initiated, or if suppose the adjudicating authority admits the application, the board will be suspended. The board of directors of the corporate entity will be suspended, and this proposed IRP, the IRP who will be appointed by the adjudicating authority, shall be replacing the board, and he shall exercise such functions the board will exercise. That is the power given to a insolvency resolution, or interim resolution professional in this case. So now the condition number 3, which they look into, is that in the application he would have named, let us say Mr. Aditya or Mr. Achyut or Mr. Vikas is so and so the insolvency resolution professional. So in that insolvency resolution professional, does he have any disciplinary proceeding against him? If the answer is no, in such cases the condition number 3 is also fulfilled. Now the condition number 4, this is exclusively for operational creditors. So as I said, in the Mobilox Innovations Private Limited case, they have discussed in detail about the existence of dispute, in which we discussed in the earlier slide. So where there is no where you believe there is no existence of dispute, then you have to give an affidavit that there is no existence of dispute. In these are the situations where the corporate debtor did not dispute the fact that there is an existence of dispute. However, where a corporate debtor says that no, there was an existence of dispute, in such cases as well, the operational creditor shall file an affidavit stating that even though the corporate debtor is stating there is an existence of dispute, but these are the following reasons or the grounds on which I believe there was no existence of dispute, and hence the application has to be admitted. So this is condition number 4. So where all these 5 conditions are met, the adjudicating authority shall admit the application. So this is stage 3, that is admission or rejection of application. I hope the stage 3 is clear. This is very important. And one important point here, as Mr. Pranjal has raised a query asking in terms of what is the timeline within which the adjudicating authority shall either admit or reject. That is the 14 days which is stated, whether it is mandatory or not. So here I would like to mention you that the moment in CIRP has been initiated, that is an application has been filed, as per the court, the adjudicating authority has 14 days within which it has to dispose such application. Disposal by which I mean whether you have to admit it or reject it. But in most of the practical cases, that is not a feasible time period within which an adjudicating authority is able to come with a decision. So what is the court say? Fine, because there in a court can usually not all timelines are mandatory. There are 2 timelines which are directory in nature, and this is one such case in the code. So it has to be interpreted in that manner only. And secondly, the code also has been amended to further say that when there is a delay beyond 14 days, the adjudicating authority has to give a reason for its delay. If that is being met, the adjudicating authority is fulfilling its duty. So that is one query which has been raised by Mr. That is one query which is raised by Mr. Pranjal, which I tried to address. If there are no other questions, we will move forward. Sorry, we have one more question. I did that, yeah. Do we have any other question on stage 3? I pause here for a minute before which I go to the next slide before I change. No. So I take it as a no. Now stage 4. So the stage 4, I split it into 4 substages: stage 4A, 4B, 4C, and 4D. So now what is this stage 4A? So till now, whatever we have seen is not the CIRP. In fact, this is stage 4 is the CIRP. So there was a occurrence of default. Then the aggrieved party wants to initiate CIRP, and then whether the adjudicating authority is deciding whether such application can be admitted or rejected. So now, what if the adjudicating authority approved, or let us say admitted the application? The moment an application application by the adjudicating authority is approved, the insolvency is commenced. So that is the corporate insolvency resolution process has been set. So yeah. So before I go further, I just want to confirm that I'm audible, because no, I'm not getting any questions from you. Maybe can you people just confirm in writing that it's just if my audio is audible and there is no break in the voice or something, because this is very important from now. The stages are really important, and hence I think we will be also spending considerable amount of time on the stages henceforth. You can just type it in the Q&A that, yeah, sure. Great. Yeah, the word yes gives a lot of boost. So let's go forward. Stage 4, that is the corporate insolvency resolution process, the triggering of the term called insolvency commencement date. So what is this insolvency commencement date? Under the IBC, the insolvency commencement date has been defined as the date of order of admission by the adjudicating authority, or the appointment of interim resolution professional, whichever is later. So now again, let me once for all clarify the role of an interim resolution professional. Under the code, there is a paradigm shift in which by how you going to deal with such insolvent companies, and that shift is from debtor in possession to creditor in control. But as a creditor, do you think you can have all that the required skills to handle a company? The answer should be, in majority of the probability, the answer should be no. So who should take care in a fiduciary responsibility for a COC, or for a creditor? So there should be some individual who has that knowledge, skill, potential, at the same time the commitment to ensure that a corporate which is undergoing insolvency, which is under deep stress, is being functioning. So such person is the interim resolution professional, or rather resolution professional. Why do we call him interim? Because right at this point of time, there might be only one creditor who is initiating CIRP. But do you think only one creditor can decide who shall take care of the management of the company? The answer should be no, because you cannot unitarily, no individual creditor shall unitarily decide who can go ahead with the management of the affairs. And hence, this person, before confirmation from all other creditors, will be termed as interim resolution professional. So why is it that the commencement date is linked with the appointment of interim resolution professional? The reason is that unless an interim resolution professional is appointed, who's taking care of such insolvent company? The law says you cannot give it to the debtor in control, the existing debtor. The law also says the creditor cannot take control. And hence, until and unless an IRP is going to take control, how can you say that the insolvency has been commenced? And that was the agenda with which the insolvency commencement date has been defined as a date of admission by the adjudicating authority, or appointment of IRP, whichever is later. However, here I would just like to mention that in the recent bill introduced in the Lok Sabha, they tried to amend this definition to simply state that insolvency commencement date shall be the date of admission by the adjudicating authority. So now maybe you just keep it in mind, both the things, but the code would be amended in the due course of time to say that the insolvency commencement date is the date of admission of the application by the adjudicating authority. So now what is the first and foremost thing which happens on insolvency commencement date is appointment of an IRP. I'm sliding it further down. I hope everyone has got the picture there. Correct? Fine. So first and foremost thing is okay. I'm sorry, I'll just hold for a minute here. Mr. Vikas, when you say video, are you referring to me? Like, are you not able to see me? That's what you're saying? Or Because when the slides are clear, I think what is the exact issue? If you can say, maybe we will try to address that. Because during the presentation of the slides, my video will not be visible. Only my audio is something which can be there. Because to avoid unnecessary distraction, we ensured that only the slide would be presented. So if at all the slide you are able to watch it clearly, then I think it's well and good. So now, so from now on, I insist you people to concentrate on my instructions, because since it is a flow of information, my instructions carry a huge amount of weightage. So firstly, focus on this appointment of IRP. So as I said, the initiation part is appointment of an IRP. Okay, fine. So now, when an insolvency is commenced, the the beauty of the code is that the moment the insolvency is commenced, a moratorium will be declared by the adjudicating authority. So that is the second point which you can see there, declaration of moratorium. What is this moratorium? Moratorium is nothing but standstill. That is freezing. I'm just freezing the corporate debtor, saying that no one can touch this corporate debtor during this insolvency resolution period. So why is this saying? Why do you want to say that pending litigation shall stop, no new litigation shall be initiated? The corporate debtor, if he is in the possession, if he is in the building of a, if suppose he is taken a building on lease and the owner is someone else, even he cannot ask the possession from this lessee, even if there is a breach. Like why all this kind of protection by way of moratorium? So I hope you understand the word or the gravity of moratorium. Moratorium is a standstill. It's a freezing of period. You can say it's a cooling off period where no claims can be made. I mean, sorry, no allegations, or you can say no cases, no proceedings, no suits can be made against the corporate debtor. So what is the requirement of it? The requirement is that, since as again, if you go back to the initial point where I said the intention of the code is for time bound resolution. So for me to have a time bound resolution, the IRP cannot go on fighting with the existing cases or to defend the cases which might be initiated during this period. And hence law says that, okay, IRP, I provide you with moratorium. No third party will come and initiate any case against the corporate debtor. Neither will the existing cases be continued. But during this period, show me that the moratorium is worth it. Show me that you can turn around the company, or get people who can take this company and go ahead. That is maximization of value of assets. To protect the value of assets, to preserve the value of assets, moratorium shall be declared by the adjudicating authority. There is also the other side of the school. There is a school of thought which also states why moratorium, right? But we are not going into that debate now. We are now going into only with the spirit of the code. Now, the third point is taking over the management of the company. So the IRP, the moment the insolvency is triggered, IRP will totally take over the management of the corporate debtor. So how does it do it? So practically how it happens, on you copy of the order, go to the management, go to the company and let them know that right from today the board is suspended and I am the board of director. I am the entire board, and I am going to run the company the way I want it to be run. So that is how it should happen. And as an after effect, the most important thing as an IRP one should do is to take control of the bank accounts by changing the signatories. Why is it very important? Because any transaction happens through the bank accounts. Any transaction, the payments happen to the bank accounts. The checks made are through the bank accounts. The changing of signatories is foremost important, and that reflects your taking control over the management of the company. I hope that's making sense. And next, talking about the necessity of interim finance. So what is this concept of interim finance? The moment insolvency commencement has been triggered, you know that the company is already undergoing stress. So where I say that the company, the IRP, the insolvency resolution, or the interim resolution professional shall resolve the company, or shall ensure that the company is going as a is run as a going concern basis. How can all this happen without the IRP having funds within the company? Right. So where there are no funds, there is a necessity of interim finance. So the moment insolvency commencement is triggered, the IRP has to also think whether there is any requirement of interim finance for me. The word interim suggests that this is a finance which is taken for an interim period, that is after insolvency has been commenced and before the company is resolved. In order to incur the expenses during this period, we term it as a interim finance. right? So now coming to the timelines part. So what happens after the insolvency commencement happens? After the appointment of IRP, within 3 days of his or her appointment, such IRP shall issue a public announcement. So if you can follow that web of arrow towards the issue of public announcement, we have stated 3 days under Regulation 6, Sub-Regulation 1 of Insolvency and Bankruptcy Board of India, Insolvency Resolution Process for Corporate Persons Regulations 2016. What does it say? It says that within 3 days, the IRP who is appointed shall issue a public announcement. So what is this public announcement? So this public announcement is effectively communicating to the public at large that, dear public, this so and so corporate debtor is now under insolvency, the board is suspended, and I am the boss now. So if you have any claims against this corporate debtor, please do file such claims, is something which is stated in a public announcement. Exactly not what I said, but the intention is that, or the content is that. Excuse me. So the public announcement effectively invites claims from the necessary stakeholders whosoever have claims against the corporate debtor, and such public announcement is made in form A. So there is a stipulated format in which you have to make. So there is no rocket science here as to you thinking what kind of details I have to put in. The entire format has been given, where again you'll give the details of the corporate debtor, when the initiation of CIRP has been done, when the admission has been done, when the order of NCLT has been passed, who is the IRP, what is the address of the IRP, and claims of how do they file the claims. And this is very important. How do they file the claims? So the operational creditors, financial creditors, file the claims, financial creditors file the claims. So the operational creditors file the claim in Form C, and the financial creditors file the claims in Form B. So this is what is the filing of the claims by the operational and financial creditor, and even that will be stated in the public announcement as to how they can file their claims. So now this stipulation has been made under the code as well as with the regulations. So the CIRP regulation is nothing but the regulation which I stated quite earlier. So this public announcement effectively is to invite claims from the public. So what is this funda? Why are we inviting claims from the public? So now the company is undergoing insolvency. Assume you would have given loans to the company thinking the company is going to give you monies in future, or assume you have provided services to the company on a credit basis, assuming the company is going to generate certain revenues. But now that you realize, now that the company is into insolvency, and if you are not aware that the company is into insolvency, that is totally not genuine in terms of the economy by which the businesses are being run. So what should be done? What is the probable possibility, or let us say the a good measure of corporate governance is to give a public announcement and state to the public that the company is under insolvency. Now, why are we asking claims from everyone right on today? So here, when I ask for claims, I also stipulate as an IRP in the public announcement that claims as on the insolvency commencement date shall only be admitted, or shall only be allowed. So what is it that I am doing? Let us say in our example again, that ABC Limited has has defaulted on 1st of December. On 5th of December, ICICI Bank has initiated CIRP. On 19th of December, the adjudicating authority had admitted the application. On, let us say, on 23rd of December, the IRP has been appointed. So from the date of appointment of IRP, within 3 days, that is 26th of December, within which I have to give a public announcement. Now, what is the insolvency commencement date? Either the admission date, appointment of IRP, whichever is later. So in this case, the appointment of IRP is 23rd, that is later. So from 23rd, within 3 days. So now the appointment of IRP and 3 days, there is a public announcement has to be made. And on the public announcement, what do you say? I say that please submit your claims as what is your claims as on the insolvency commencement date. So here the insolvency commencement in our example is 23rd December. That is the appointment of IRP, whichever is later, right? So as on that date, whatever are your claims, totally, even though your claim is not due today, even though your claim is due 10 years hence, you still have to file your claims now. Only then me as an IRP can establish what kind of claims are being made. So this is the funda behind having a issue of public announcement, asking people to submit their claims against this corporate debtor. Okay, now, sorry, yeah, so we have a question here. So it's something which we have to address right here. So the question says, yeah, the claim includes immature claims. So now the definition of claims covers various aspects into its view, which are disputed claims, undisputed claims, or future claims, the right to payments, and also the legal, equitable, secured or unsecured claims. Yeah. So now coming to the unmatured claim. So if you look at the definition of the claim itself, it is divided into two. One in terms of right to payment, second in terms of right to remedy for breach of contract under any law. So under right to remedy for breach of contract under any law, you can still go ahead by way of filing your claim as an unmatured claim. Yeah. Subsequent point in terms of the unmatured claims is that where there is an unmatured claim and that is arising out of a breach of a contract, the person can file for such claim, can submit such claim. However, it is upon the prerogative of the RP to look into and verify such claim and verify the authenticity of such claim based upon the documents such claimant provides for. So, yes, to answer this question, yes, unmatured claims can also be filed under this code and as a claim. Any other question in terms of claims? I can also give you an interesting analogy in terms of the claims part, but we will do it maybe at a later point of time because we have a procedure to be covered and within the time slot we have. Now, after the public announcement has been issued and the claims have been invited, the next thing is from the questions, that is, as Ms. Urvashi has rightly pointed out, the submission of claims. So maybe she has a claim which is disputed or unmatured or any other such kind of a secured or unsecured claim. All such claims shall be submitted before the IRP. And now, if you keenly look into the timeline from the date of appointment of IRP, within 14 days, the submission of claims have to be made. So even though you make a public announcement within 3 days, not from that day I count for the submission, but the submission of claims will be counted from the date of the appointment of IRP. Yeah. So yeah, before we go for the question asked by Ms. Urvashi is also related to the submission of claims. So I will address it here. So within 14 days from the appointment of IRP, all the people have to submit their claims. So why is the 14 days relevant here? Because of the concept of committee of creditors. So what is this concept of committee of creditors? So now that when we said that there is a shift of paradigm shift from the debtor in possession to creditor in control. Who is this creditor in control? There has to be a certain body. You cannot even rely on an IRP to completely manage unilaterally. So there has to be a body which is superior to the IRP, not in all manners, but there should be some body for the checks and manners. So that kind of a body is committee of creditors, and this committee of creditors comprises completely of the financial creditors alone. Now the committee being comprising of financial creditors alone, and how can the IRP know who are such financial creditors, and also what kind of claims such a financial creditors might have, right? So in order for that to happen, first initially the code requires major decisions to be taken by the committee of creditors. So unless I constitute a committee of creditors, I basically cannot resolve the company. So where I need to constitute a committee of creditors, I need to know who the creditors are. So in order for me to know who the creditors are, I need to get the claims. So that is why the relevance of submission of claims, and the time period of 14 days, the relevance is that to constitute COC at the earliest time possible. So within 14 days we receive the claims. The submission of claims from the appointment of IRP is something which is done, and after the claims have been received within the 14 days, within 7 days thereof, you can find that arrow as well from the submission of claims. Within 7 days, verification of claims will be done. And this verification of claims is also the responsibility of the IRP. So submission of claims is also, when you submit the claims, the IRP shall receive such claim and collate such claims as per section 80, which is the duties of the interim resolution professional. And within 7 days of such submission of claims, the IRP shall also verify such claims. And when I say verify, I need to look into the documents provided, whether the documents are substantiating the amount of claims being made. So now here I'm going to address the question raised by Ms. Urvashi Shah, that is the quantified. Should I quantify the amount of claim? And the answer is yes. So why the answer is yes? Because when you are submitting the claim form also clearly asks for what is your amount of claim. And unless you quantify as an IRP, I will not get to know what kind of a debt you have. So why do I need to know what kind of a debt you have? Because that determines your voting power in the committee of creditors. And hence, submission or quantifying the amount of claim is really important. And number two, if suppose let us take a scenario where a claimant says that, okay, let the IRP quantify my claim, this is the document. In such case, IRP is taking the role of adjudication, which is not the intention. IRP cannot adjudicate. I can receive the claim, collect the claim, and verify it in terms of whatever the documents you have given. If your document is supporting your claim, I would admit it. If your document is not supporting your claim, I would still categorize that claim as zero, or say that it is the existing documents cannot substantiate the claim for the simple reason that your documents cannot help me in verifying your claim. I hope this addresses your query, Ms. Urushi. Coming to verification of claims. So again, as I said earlier, it's stipulated under the regulations, regulation 15, and it is the responsibility of the IRP. Now, let me just take you again back there. If you can just look at the slide now, I took you again to the above. I hope we are there. So maybe just a second. Are we? No. So if you would have observed to your right, there is a timeline which is 90 days. So even though I said that from the appointment of IRP within 14 days submission of claims have to be made, what if all people did not get the notice and they were not able to make the claims within this 14 days? So that is when the law also provided that, do not worry, this 14 days is basically for you to represent it before the COC. So all these financial creditors should strive to file it before the 14 days. But if you are not in a position to file it within the 14 days, then the law also provides for you to file within 90 days from the insolvency commencement date. So from the insolvency commencement date, within 90 days, your claims will be, claims can be filed, and the RP is authorized to receive your claims till the 90th day from the date of insolvency commencement date. I hope this is clear. So I'm going again down from to the verification of claim. So again, the same procedure happens even within 90 days or 40 days when to submit. Within 7 days, I have to verify the claims. Right. So now, the initial stage, that is within 14 days, I've received the claims. Within 7 days, I have verified the claims. Now, what do I do? Within next 2 days, I need to constitute COC. I need to constitute COC and file the same before the adjudicating authority, stating that honorable adjudicating authority, this is the COC of this corporate debtor, the claims which I have received within this 14 days. And how do I constitute COC? Take a hypothetical example. Let us say there are 3 creditors of a corporate debtor. Creditor A owes, let us say, has a claim of 40 rupees. Creditor B has a claim of 30 rupees. Creditor C has a claim of 30 rupees. In such cases, creditors comprises, let us assuming all the 3 are financial creditors, COC will comprise only of these 3 creditors, creditor A, creditor C, and creditor A will have 40% voting rate, creditor B will have 30% voting rate, and creditor C the balance 30% voting rate. So your claim, the percentage of debt or the claim over the overall debt will decide your voting share. So now let us take a tricky scenario. Let us say only these 3 creditors have submitted their claims within the 14 days. Now assuming there are various creditors who are submitting their claims beyond this 14 days, let us say 18th day, 25th day, or 32nd day. So now does this mean that they do away with their right of voting? The answer is no. Not, of course, constituted as COC at the initial stage, that is within the 2 days, but later this constitution will be revised. Their claims also will be admitted. They also will be taken on to the COC. However, the earlier decisions of the COC will have no impact. The subsequent decisions will have an impact. The voting share might vary. Suppose the same example I have given, let us say creditor D files a claim on a 45th day, and he says, I have a debt of 100. So now all of a sudden your debt has become 200. So the rest of the people who have enjoyed the share of 40, 30, 30 will now have 20, 15, 15, and the balance of the stake will be lying, 50 will be lying with the creditor D. So that is how a COC is constituted. It is a simple math. The whatever is the total debt, your portion of the total debt, that will be your voting share in a COC. But under COC, 2 important things you need to remember. Point number 1, COC comprises only and solely of financial creditors. and not operational creditors. You might ask, what if there are no financial creditors? And it's a valid question, of course. Where there are no financial creditors, the operational creditors not exceeding 18 in number shall constitute the committee of creditors. And a second important point under the committee of creditors you need to keep into mind is this committee of creditors decides major decisions, and one important decision is whether to continue the interim resolution professional as the resolution professional or not. So as I said, the resolution professional is the one who is going to deal with the management of the affairs of the company, and the interim resolution professional is only till the COC has been constituted, because that is why he is termed as interim. So such he or she resolution professional, the COC will look into whether they are capable enough to go ahead, or if all the committee of creditors will vote on it, and where a favorable vote has been received, 50 or 66, where a favorable vote has been received, the interim resolution professional can be continued as a resolution professional, or where the committee of creditors opine that this IRP cannot handle this project, and they can opt for someone from their own panel or any other operation or any other resolution professional. And if the favorable vote has been received in favor of such resolution professional, then he or she shall be appointed as the resolution professional. So now so this stage which we discussed here is upon admission of application by the adjudicating authority, that is CIRP stage A. So where a committee of creditors has been, constituted. Now we are going ahead with the next stage, that is what happens after the committee of creditors has been constituted. So in case there are any questions, you may please ask now. So because anyways there is a delay of some 4 to 5 seconds before I go for the subsequent slide. Hence, in case you have any questions, we can look into it. Is the screen on? Yeah, any questions? Is the slide on? Okay, so we have a question here. Okay. Okay. So Achyut, it says the 14-day period within which the adjudicating authority has passed an order is only directive but not mandatory. Yeah. So that's absolutely right. That was what we have discussed earlier as well. The 14-day period is absolutely directory, and however, the court still mandates the adjudicating authority to give a reasoned order stating the delay beyond the 14 days. So rather than imposing a restriction, or rather than having asking the company to come, the adjudicating authority to mandate itself to 14 days, the court requires the adjudicating authority to give a reason for the delay beyond the 14 days. Point well taken, Mr. Achyut. Now let us now that the screen is on, now we are in stage 4B, that is the second major part or major chunk of the corporate insolvency resolution process, which is after constitution of the COC. So here, right next to the constitution of COC, you can find the word ICD. Why did I put it there? You will know the relevance very shortly, because under the code there are certain trigger points which are related to the ICD, and there are certain triggers which come from appointment of ARP. There are certain triggers which are from appointment of RP. So hence, to accommodate all that in one infographic, I had to put this ICD right next there, even though it is out of context. So now what happens after a COC has been constituted? You have seen that there is a public announcement made. There were claims which have been called for in the public announcement. Claims have been submitted. I have verified the claims. Based on the verification, within 14 plus 7 days, I have constituted a COC. After constitution of COC, the COC within 7 days of its constitution, that within 7 days of which I report to the adjudicating authority of its constitution, it has to meet. So all those members under the report which I made to the adjudicating authority, they have to meet. That is the first meeting of the committee of creditors. I use the word COC, which is nothing but committee of creditors. So who are these committee of creditors again? They are the financial creditors. And what is the first and the foremost important thing they do in the first meeting of the COC? They do is to appoint an RP, and this appointment is made by way of 66% of the voting. So if 66% of the creditors having value, so the 66% of the creditors representing 66% of that. So the intention is those creditors representing 66% of the total debt admitted till that time, if they pass in favor of any resolution professional, appointing a existing IRP, the interim resolution professional, as a resolution professional, or appointing any additional person, or let us say any third, like any other person as a resolution professional, it can happen only in that COC meeting, in the first meeting of the COC, and that is by way of 66% of by way of credit debt representing 66%. Now, after the appointment of RP is done, what other important things do they discuss in the first meeting of COC? Number two, they will take note of the activities which all the activities which have been undertaken by the IRP till date, because till date IRP is functioning majorly on the instructions might be given by one of the applicant. The applicant might be one financial creditor, might be one operation creditor, or maybe the corporate creditor itself. In either of the case, he might be prone to the instructions received from them, or maybe he's taken a decision on his own. So whatever is it, what happened till date, I just need to have a review. So the progress report. So what happened till date? The note activities which have been undertaken by me, by the IRP, shall be taken note by the COC prudently. Third, there might be certain costs incurred by the IRP. So it is the responsibility of the COC to ratify such costs. So maybe some costs are like completely beyond the scope that which you may rebut. So there may be some genuine costs. Maybe the IRP would have incurred out of his pocket, or the services for which the services the IRP has served till date. So for all that, you can ratify such costs. And then, if at all, so there is section 28 of the Insolvency and Bankruptcy Code, which mandates for various in principle approvals or prior approvals from the COC. So such section of among many things, it also talks about of interim resolution finance by the resolution professional. So as I stated earlier, there might be a requirement of certain fund. So if you need to raise such fund, the quantum of fund you should take a approval from the committee of creditors, and the upper limit of expenses. So if you want to spend certain expenses, yes, you can still spend it. However, the upper limit is something which the committee of creditors will decide, and you need to take an approval for it. Supposedly you need to continue to undertake any related party transactions, which is important critically for the company. So even for that, you need to take an approval from the committee of creditors. And hence, wherever there is a requirement of approval from the committee of creditors, the IRP has to specify the same in the agenda of the meeting of the COC. The first meeting is something which is vital for the appointment of RP, but the rest of the things, that is taking note of activities by the IRP or the RP, as the case may be, ratification of costs or the approvals, usually happen in all subsequent meetings. So now, till now, we have only we use the word IRP. So from now, the stage has been set for the RP to take over the control. So what is this RP again? The same role of the IRP, the resolution professional now. So he is the final. So the IRP is only interim. He is the final person. Again, now if you can observe that line, which is parallel to the which is horizontal to the RP, appointment of RP. So that again now triggers various events. So what is this event? First event which it triggers is appointment of registered valuers. So, and I wish to spend a fair bit of value. I want to give a value addition to this at this juncture. So what is the concept of a registered valuer, and why is that a valuation required under for a company which is sinking? So as I said, the code, that is the IBC, is hinting at resolution, and where resolution is not possible, liquidation, which means if I want to resolve, I need some third party, that is some person who is not related to the existing promoters, who is not the existing promoter, to come and take over these assets and put it to the best use. So taking the example of SR Steel, what happened in the case of SR Steel? SR Steel has been facing insolvency, and hence what happened? It went into, they have given public announcement, claims have been filed, IRP, that is Mr. Satish Kumar Gupta, has been appointed, Arvind Marshall was the consultant. They have engaged, they went across various applicants, that is the various prospective investors they have approached, and such prospective investors are termed as resolution applicants under the code, and they have pitched in how this acquisition, or let us say how this asset of the SR can help the companies, and accordingly ArcelorMittal has come up with this bid of the 42,000 crore, which you would have seen on the newspapers, and all this is possible because of what? Because of the code. And now, when I say all this is possible, how did they come up with the figure of 42,000 crore? There might be certain valuations done. And how did the COC approve such 42,000 crore? There should have been certain valuations done. And now when I say the word valuation, who is the best person to do the valuation other than the registered valuers? And that's where the requirement of appointment and also the requirement of valuation. And what are the values which I determine? I determine two values, one a fair value, two a liquidation value. Fair value is for the resolution, liquidation value is for the liquidation. So what is this fair value? It is again defined under the code. So without going much into the fair value, I'll simply put it in such a way that, the registered valuer will imagine, will not think the company is undergoing insolvency. He will just imagine that the company is a willing seller. There is a willing buyer in the market. All other market forces or all other conditions are knowledgeable to both the parties. And hence, if they want to enter into a sale of this entire asset, what kind of value or what kind of value the buyer would be ready to pay, what value of money at which the seller will be ready to sell, that is what is the fair value. So to determine such fair value, they need to rely on the international valuation standards which have been prescribed, the IBS 2017 till now, because there was no such international valuation standard which we have adopted up exclusively for this. So such registered valuer will come up with a fair value and a liquidation value. So this appointment of registered valuer is entirely the prerogative of the resolution professional. And if you can see here, the tricky part is a COC is not empowered to appoint registered valuer, but a RP is empowered to appoint registered valuer. So these two registered valuers are being appointed by the RP alone, and the valuation report submitted by the registered valuers is also confidential. It will lie only with the resolution professional till the bids received from the prospective investors, that is the resolution applicants, have been evaluated. That we will be looking into in the subsequent slides. So now after the appointment of registered valuers has been, also if you can look into the arrow, the appointment of registered valuer is also linked with the ICD, that is insolvency commencement date. So such appointment of registered valuers has to happen within 47 days from the insolvency commencement date, or within 7 days from the appointment of RP. So these two deadlines have to be complied with by the company. Okay, sorry, so complied with by the RP. Now, after the appointment of registered valuers, the other important thing is preparation of information memorandum. And when do we, so before even I tell about information memorandum, let us just talk about what is the time frame within which I have to prepare this document. Just think that it is one document, information memorandum. From the ICD, within 54 days, I have to come up with preparation. I have to finish the preparation, the information memorandum. And not just that, from the appointment of RP, within 2 weeks, the IM has to be prepared. So IM is nothing but information memorandum. So first question, who prepares an information memorandum? Resolution professional. Now, what is an information memorandum? So this is not a new concept. This is not a new term introduced under the IBC. So where did we earlier read about this information memorandum? So for those students of the law, and also for students, or for the company secretary students, or for other professionals. So information memorandum we have seen under the ICDR regulations, the issue of capital and disclosure requirement regulations. So when does someone give a IM, information memorandum? So where you have given a shelf prospectus for a year, and now after the issuing of shelf prospectus, that which is valid for 1 year, within 1 year you can raise many issues. So now for every issue you will come with a IM, which is information memorandum, which gives a fair bit of information about the company, which may be deviation from the shelf prospectus, and there may be certain additional information. So this is something for those who would have related to the IP, the prospectus and all. I just want you to be comfortable with this term. That's why I gave this example. For those who are not at all aware of this, I will explain what an information memorandum is. It is nothing but a document which provides information. As simple as that. A document which provides information, both quantitative as well as qualitative, about an entity is what is an information memorandum. So the information memorandum has to be prepared by the resolution professional, and such information memorandum has to be submitted to every member of the COC. So what is contained in such information memorandum? It basically gives a description of all the assets and liabilities of the corporate debtor, It provides the latest annual financial statements, the last 2 financial year audited financial statements for the last 2 years, the list of all the creditors along with their names and the claims, the particulars of the debts which have been due with respect to the related parties, either it be due from the related parties or due to the related parties. All the related party claims also has to be separately disclosed. If there are any guarantees whichever has been issued by the corporate debtor, even that has to be mentioned. All the material litigations have to be specified as to where the material litigations are there, or if there is any ongoing investigation, the same has to be specified. And in addition to it, we'll also specify if there is any material litigation in terms of those initiated by the government, and what are the claims from the workmen and the employees. All these form part of your information memorandum. So from this, you can understand that this document is trying to give a fair bit of idea to the prospective investors, that is the resolution applicants, to understand the basics of this company, whether this company has such funds, whether the company has assets, is this company operationally viable. So all this information you're providing is to the resolution applicant. So as an RP, I shall make such information memorandum in such a way that it would attract the investors. It would help the, sorry, like attraction might be a fancy word, but still it would help the investors to understand the very business of the corporate debtor, the status of the assets and liabilities of the corporate debtor, the claims, what are the total claims of the corporate debtor. The information memorandum will help them understand that. So for the preparation of information memorandum, the timelines as we have discussed earlier. So now, the subsequent part, after preparation of information memorandum, we need to go for something called as EOI. This is another important leg in this stage. So before I start with the EOI, I invite certain questions. If there are any questions, I wish to address it right now. Are we on the same page? Is everyone able to understand, or are you comfortable with the way I'm teaching, my speed and all? Sure. So I hope the screen is on. Yeah, the screen is on now. Okay, so I think there is more time required to wait here. Yeah, it's on. Fine. Uh, I hope, like, since there are no questions asked, I take it as a no from you. I'm continuing with the EOI. So, as I said earlier, the RP is appointed and the RP appoints registered valuers. RP also is preparing an information memorandum, providing the status of the assets, liabilities, list of claims, and all. So, now after this, what does the RP do? Why is RP doing all this pain, taking all this pain of preparing an IM? Because he needs certain investors. So, these investors are termed as resolution applicants. So now again, I just want to again spend 30 seconds or 40 seconds on the concept of this aspect of expression of interest, and what is the requirement of you needing fund from some third parties. So the code basically says that where there are assets and where there is a viability of using such assets, and where the existing corporate debtor is not in a position to put these assets to the best use, rather give it to someone who can put it to the best use. So that is what is the exercise which we are doing here. So what are we doing as an RP? I am inviting expression of interest from the public. So I publish an expression of invitation for expression of interest in form G as per regulation 36A in various, in the English, in one English newspaper and regional newspapers, wherein what is the content of this invitation for expression of interest? It says that, the public, this is so and so RP of so and so corporate debtor, and I hereby invite expression of interest from you to take over or to resolve this entity. So come up with your plan. How do you resolve this entity? There are various claims. How do you pay off these claims? So you pay off the claim, take over the control of the company. That is what is an invitation for expression of interest. So what else will I prescribe in an expression of interest? In an invitation for expression of interest, I say that this invitation is not for the entire public. Not Tom, Dick and Harry can come and apply for, you can just file for an EOI. So I prescribe an eligibility criteria. So depending upon the business of the corporate debtor, depending upon the scale and scalability and you can say the large balance sheet, or the, not may not be large, but depending on the balance sheet and also the scalability of the corporate debtor, the eligibility criteria will be something which will be specified. And not just this, in addition to the scalability, we'll also look into the total claims made by the parties. So depending upon all this, eligibility criteria will be ascertained, and this eligibility criteria will also be disclosed in the EOI. So it necessarily says that whosoever is meeting this eligibility criteria will have a right to apply, to file for a resolution plan before of to take over. I mean, so to file for a resolution plan to resolve this entity by way of paying off debts, paying off claims to the creditors, and for as a return of which the quid pro quo, I give you the control over the corporate debtor. How do you want to take the control, and all that stuff will be forming part of your resolution plan. So what is this invitation for expression of interest? Is inviting you to submit your expression of interest to submit a resolution plan. So EOI only in terms of expression of interest to submit a resolution plan, right? So this is the concept of EOI. So the extension of the EOI part will be discussed in detail in the next stage, but giving importance to the timelines, if you can see there, this invitation for expression of interest has to be specified, has to be given within 75 days from the insolvency commencement date. Agreed? Along with this invitation for expression of interest, there is one more compliance which the RP do under this CIRP procedure. So this step is forming an opinion on preferential transactions. So what is this preferential transactions? In the past, there might be certain transactions where the corporate debtor would have shown certain preference, that is usually related party transactions, where if the market is demanding 80 rupees, you pay him 120 rupees. Where a market is giving you 100 rupees, you take 80 rupees from such person. So there is a preferential treatment which has been given. So initial prima facie opinion has to be formed by the RP within 75 days. And within 115 days from the ICD, insolvency commencement date, the RP shall determine what are the preferential transactions, what are not the preferential transactions, and what kind of impact that had on the cash flows of the company. And within 135 days, the RP shall file an application with the adjudicating authority stating that honorable adjudicating authority, these are the preferential transactions, and this is the appropriate relief which I am claiming with respect to such preferential transactions, and the honorable adjudicating authority may be pleased to honor or let us say order to pass a necessary order in this regard. So that is how I approach the adjudicating authority within 135 days from the insolvency commencement date. So the 75, 115 and 135 days are essentially the requirements, the procedural requirements. Okay? So there is no requirement of spending more time on this, because these are this is a separate topic on its own. So since it is a procedure, I had to get it inside this, but have your focus more on the invitation for expression of interest. So now I have invited for expression of interest from a prospective investors. So what happens after I invite expression of interest will be discussed in detail in the subsequent slide. So now that I went to subsequent slide, and since I know there is a considerable amount of delay which is taking place, I again invite questions from the people. In case you have any questions, you are welcome. How many are watching? Okay. So no questions. That's fine. So hope at least try to acknowledge if you are understanding it. So that way I can be confident that I'm able to convey it to you in the fullest. Okay, that's great. The screen is on. As usual, the questions, the Q&A is still on. You can have ask your questions there. So right now I'm going to stage 4C, wherein after the issue of invitation for EOI, what essentially happens is within 15 days of such issue of invitation for EOI, any prospective party who is interested to file or who is interested to come forward with a resolution plan can submit a EOI, which is expression of interest, which is nothing but a third party, say let us say in the same, let us take the example of the SR Steel only, how ArcelorMittal has has won the bid. So firstly, the RP, that is Mr. Satish Kumar Gupta, has issued a invitation for expression of interest. So after issue of invitation for expression of interest, ArcelorMittal has filed its EOI, that is expression of interest. They submitted it within the stipulated time period. And what is the time period? Within 15 days from the from the date of issue of invitation for EOI, expression of interest has to be received. And within 10 days thereof, a provisional list of resolution applicants has to be prepared. I'm sorry. So within 10 days from the submission of the expression of interest, the resolution professional will prepare a provisional list of resolution applicants. And what is this provisional list? So whosoever are the parties who are the applicants who are meeting the eligibility criteria will be coming under the resolution applicants here. They will be the provisional list. Okay. So from this provisional list, which has to be prepared within 10 days from the date of submission of the EOI, the RP will prepare and it will forward that list to the COC and also to all the applicants. So what is it doing here effectively is that it is giving an opportunity for the COC to object them and also for the applicants to object. So suppose I do not include a name of an applicant under the provisional list, in such case the provisional list, such applicant can file an objection stating that it is eligible to file an application under this code. So that is what is the opportunity. The code, since it is again in a time bound manner, does not wait for the objections from such applicants. Rather, it proceeds with the next step. So what is the next step? Next step is, after preparation of provisional list, within 5 days, the resolution professional has an obligation to issue 3 important documents to such RPs. And these are the 3 important documents which will help the resolution applicant to come up with a resolution plan. So now I'll just spend a fair amount of time on what is a resolution plan. A resolution plan is a document which is filed by a resolution applicant wherein it proposes as to how it is going to address the cause of insolvency of the corporate debtor, and also how it is going to infuse funds, how it is going to revive the corporate debtor, how is it going to pay off all the claimants whichever has been disclosed in the whatever are the claimants there. Fine. So that is what is the basic of a resolution plan. So now that a provisional list of resolution applicants has been prepared, so what happens next? So what happens next is that the resolution professional within 5 days of such preparation of provisional list has 2 basic responsibilities. On one hand, it has to forward such, it has to wait for the objections from the COC. The 5 days is basically the time given for the COC to come or revert with the objections, also time given to all the applicants to revert with their objections. On the parallelly, so if you can see, there are 2 parallel arrows drawn indicating that parallelly within the 5 days, the resolution professional shall submit, as I said earlier, 3 important documents. What are they? Number 1, RFRP, request for resolution plan. Number 2, evaluation matrix. And number 3, information memorandum. I'm sorry, it's not matrix, it's memorandum. RFRP, request for resolution plan. What is this RFRP? So the code does not say what has to be there in an RFRP. It basically gives a broad overview of what an RFRP is. So as the name suggests, request for resolution plan. The RFRP covers major chunk of the details in terms of the corporate debtor, trying to give an indication as to the expectations of the financial creditors and also the other creditors, and also the level of, also giving them an idea of how the industry is, also giving them an idea as to the reasons behind the default or the reason behind the insolvency, and all such expectations are being reproduced in a document which is named as request for resolution plan. And along with request for resolution plan, if you remember, within 54 days from the date of insolvency commencement date, or within 2 weeks from the date of appointment of the RP, we prepared an information memorandum. Such information memorandum shall also be given along with the RFRP. So what are we trying to do here? We are trying to provide certain documents to the prospective resolution applicants, so that they can come up with proper plans to recover, to revive this entity, to pay off the debts to the creditors. So that is the reason why the better the information, the better the plans you would get. So request for resolution plan and information memorandum are two mandatory documents which has to specify all the basic major details pertaining to the corporate debtor. So coming to the evaluation matrix. So what is an evaluation matrix? So as the name suggests, is a matrix to evaluate the plans. So now that I am involving in evaluating various plans, I should not be showing any bias, and hence the regulations stipulate that all the resolution plans received from various resolution applicants have to be strictly evaluated in terms of the evaluation matrix. So this evaluation matrix says, let us say, it might say, okay, if you get in more upfront payment, I will give you more marks. If you lesser the deferment, I will give you more marks. Or rather, it says if you are able to address the risks in a probable fashion, I would be giving you more marks. So this evaluation matrix is basically as good as our scoring structure only, which we have it in our schools. It's like a scoring. How do I score on all these plans? And why is it important? It is important because there has to be no bias among all the resolution applicants, and that is the basic funda behind an evaluation matrix. Now, all these three documents will be given to all the resolution applicants, of course, by way of by taking a entering into a confidentiality agreement with them. Why do we enter into confidentiality agreement? Because we are disclosing confidential information, and it can be used against them, against the corporate debtor. And hence a confidentiality development agreement will be, confidential information agreement will be entered into between the parties to whom the disclosure has been made, to whom the RFRP, evaluation matrix, and the information memorandum have been made. So that's a mistake. It's not information matrix, it's an information memorandum. So this is the part. Now, if you look at this parallelly, what is happening, that there have been objections received, and within 10 days, the final list of RA is being ready. So even those final list of RA is ready, suppose any of the RA is missing from the provisional list, and you will also forward these three documents to such resolution applicant as well. So that is just a procedural aspect. So now, after issuing of resolution, a request for resolution plan, evaluation matrix, information memorandum, what do I want? As an RP, I want a plan. And what is the submission of a plan? So here, if you can observe the way it is drafted, the code does not say you shall submit within this time. It says at least 30 days time limit you have to give for submission of a plan, because you need a plan. It's not like some cut copy paste job. You need a tailor-made plan for every corporate debtor. So hence a period of 30 days has been felt to be adequate. And of course, it is practically difficult to totally understand a company in 30 days and come up with a plan to take over the company. But still, minimum 30 days buffer has been given for the purpose of coming forward with a resolution plan. So at least 30 days is time period given for submission of a resolution plan. And the moment the resolution plan has been submitted, within 2 days of the submission of the resolution plan, the resolution professional shall forward all compliant resolution plans to the COC for its consideration. So here let us spend a minute, less than a minute on this, as to what is this concept of compliant resolution plans to the COC for its consideration. So where a plan has been submitted, there are various parameters on which I look into the plan. As an RP, I need to ensure that the basic conditions provided under section 30 subsection 2 are met. So what is all of a sudden this section 30 subsection 2 of the Insolvency and Bankruptcy Code? So this section 30 is the enabling section which talks about the conditions or the basic submission of a resolution plan, wherein it says that every resolution plan has to be examined by the resolution professional to look into whether it is providing for the CIRP cost, that is Corporate Insolvency Resolution Process cost, that is the cost incurred during this period, whether they are such costs have been given the priority or not. Second, whether the operational creditor debts have been addressed in a fashion as mandated under this code or not. And third, whether the management of the affairs are being taken over by the corporate debtor after post approval or not. Fourth, whether the resolution plan talks a bit about the implementation and supervision of the plan or not. And fifth, whether the resolution plan is in contravention of any of the laws. So as an RP, I should also look into whether this plan is in contravention with any other law. So if it is in contravention with any law, it's not a compliant plan. And then any other requirements which the board might, the IBBI might come forward with any specifications, even that has to be looked into by the resolution professional. So now, after looking into all this, so here again there is one kind of interpretation. So in one case, um, uh, in the Jaypee international case, in the Jaypee infrastructure case, where the resolution professional, after even though he has received 9 resolution plans, he has only forwarded 5 resolution plans to the COC for its consideration, because only he thought fit that only 5 plans are being compliant. Similarly, on other parallel, there is a judgment in ArcelorMittal case, because the first one which I said Jaypee, that is Chitra Sharma judgment, where the Supreme Court was comfortable in stating this statement. It did not give any direction, but it made as factual description that the resolution professional has only forwarded 5 complaint plans to the COC. But on a different case, which is ArcelorMittal's case, the resolution professional forwarded only few plans which are complaint, or which is an opinion or complaint. Then such resolution applicant, being aggrieved party, made an application before the adjudicating authority, then went on to the appellate authority, then went on to the Supreme Court. The Supreme Court opined that in para 71 of that order, the Supreme Court stated that the resolution professional is not expected to send only part of the plans, or I mean, only few of the plans. The resolution professional shall forward all the plans to the COC. However, he can give his comments as to what are the plans which are compliant, what are the plans which are not. So as of now, even though the law says under section 30 subsection 3 that only compliant resolution plans have to be forwarded to the COC, but the interpretation for the precedent set by the Supreme Court should be kept in mind, and the resolution professional in a prudent basis should look into the obligation of the resolution professional will not go anywhere. He has to look into whether the requirements are being met or not, and if the requirements are not being met, it has to make a statement that the requirements are not being met, or if the requirements are being met, it has to make a statement that the compliance has been made and file its submission before the adjudicates, or file its submission before the committee of creditors for them to take their decision. So now the next stage, that is stage 4D. So stage 4D talks about approval or rejection by COC. So under stage 4D, so after after the plans have been received, the plans have been forwarded to the COC. Now COC, after evaluating, so here what happens, the COC will evaluate all the plans based on the evaluation matrix, and scores will be assigned to the individual plans, and based upon who is the highest among all such individual plans. So based on who is the highest among all such individual plans, who is the highest scorer among all such individual plans, such highest scorer in common parlance, in commercial parlance called as H1, will be put, such plan of the H1 bidder will be put forward for voting before the committee of creditors. So here the committee of creditors will decide whether to approve the plan or to reject the plan, right? So now for the approval sake, what is the percentage of approval required? Earlier it was 75, later it has been got down to 66%. So now for approval or rejection of a plan by the COC, the required percentage is 66%. And now for the purpose of approval or rejection by COC, so what happens here is the resolution, so if suppose the committee of creditors has approved the plan. Why do they approve the plan? They approve the plan because maybe they are convinced that the payments will be made, that the revaluation matrix is good, the history of the resolution applicant is perfect, the amount of bid they are getting, the haircut is less. On various factors they might approve. In addition to all this, they also have to look into the feasibility and viability of the plan. So what is the feasibility and viability? Feasibility talks about how far is this plan reliable, and viability talks about how far is this resolution applicant is affordable, or the history of the resolution applicant. So where the feasibility and viability of the plan are being met, the committee of creditors have to deliberate on it and have to ensure that their minutes cover how they deliberated on the feasibility and viability of each of the plans. In addition to this, where a plan is approved, why do you approve a plan? Where a plan is rejected, why do you reject a plan? Both of these things are very important considerations which a committee of creditors should have in their minutes. So now, assuming that a plan is approved or assuming that a plan is rejected, let us take both the scenarios. When do you think a plan will get rejected? Where where they believe that the liquidation, a liquidation value is substantiating, is getting, where they have more liquidation value than the resolution amount submitted by the resolution professional, by the resolution applicant, then the COC can decide that, it's better we go for liquidation rather than for resolution. So that is when a committee of creditors may reject the plan outright. Or second, where they never received any plan, in such case there is no possibility of even a rejection, right? So rejection is only possible in a case where there is no possibility, where the liquidation value is higher, or where you believe that the existing resolution, the other resolution plan might be favorable, or in such cases you might reject this plan and then subsequently revise the evaluation matrix, issue a fresh evaluation matrix, call for fresh resolution plans from all the final list of resolution applicants. So that is the pain which is being undertaken. So where a plan has been approved to the fullest, or let us say where the plan, where the resolution, where the committee of creditors rejects a plan, it can be either on two grounds. Number one, where the liquidation value is higher than the resolution amount, or number two, where the resolution, where the other resolution plans might be favorable, and in which cases the committee of creditors cannot simply go for H2 bidder or H3 bidder and vote on it. That is not possible. So what should the committee of creditors do? They should revise the evaluation matrix, send the evaluation matrix again to all the final list of resolution applicants, and invite resolution plans from all such resolution applicants. So that will be the repercussions, that will be the consequences of a rejection. And what happens in case it is approved? So the moment it is approved, so on what basis again be approved? As we have earlier discussed, based upon the haircuts offered, based upon the upfront payments offered, based also upon the feasibility and viability of the plan, the committee of creditors will come forward with approval of such plan. So now what happens after the committee of creditors approves the plan, or what happens after the committee of creditors rejects the plan? After the committee of creditors has approved the plan, such plan has to be filed before the adjudicating authority. Is there any time limit for this? This is again a tricky part. The code says that the resolution professional shall take every endeavor to file the resolution plan, the approved resolution plan from the COC before the adjudicating authority at least 15 days before the maximum time for the corporate insolvency resolution period. So what is this maximum time for the corporate insolvency resolution period? So section 12 of the code talks about the period for the corporate insolvency resolution period, insolvency process period. So the CIRP period initially will be 180 days unless it is a fast track insolvency process where the period will be 90 days. So and under the CIRP, the 180 days can be extended for subsequent 90 days where the committee of creditors vote for it, and the resolution professional files before the adjudicating authority. The adjudicating authority has a power to extend it for 90 days. So effectively, the total time period for CIRP is 180 plus 90, if any, that is a 270. That is the maximum time period. However, the code was amended to say that the maximum time period for CIRP shall not exceed 330 days. So even though the maximum time period, the court said that it is 330 days, in the recent judgment of SR Steel, it was held that the time period of 330 days is directory but not mandatory. Okay, so without deviating much from this, the moment the approval has been made by the COC, the resolution professional shall file the same before the adjudicating authority for its approval or rejection. So now the question comes, can an adjudicating authority reject a plan which has earlier been approved by the committee of creditors? The answer is yes. Have they did it? Again, the answer is yes. So there were various cases where an adjudicating authority had actually rejected the plans approved by the committee of creditors, and that was where the Supreme Court had held that the commercial wisdom of the committee of creditors should be recognized by the tribunal, the adjudicating authority, because adjudicating authority cannot look into the commercial wisdom of the committee of creditors. So even though even though you feel that commercially it is not a viable plan, the adjudicating authority cannot give its comments on that. Rather, the committee of creditors, it has to be completely left open for the committee of creditors. Then on what grounds can an adjudicating authority reject a resolution plans? The sole and wholesale grounds on which the adjudicating authority can reject a plan is when the plan is not meeting the criteria provided under section 30 subsection 2, which I have read earlier. That is where a plan is in contravention of any of the law, or where the adjudicating authority believes that the plan is not provided for adequate implementations, had not provided for management of the affairs, had not provided provided adequate protections to the operational creditors or the dissenting financial creditors, or the plan is silent about the corporate insolvency resolution process cost. In such cases, that the requirements under section 30 subsection 2 have not been met, the adjudicating authority can reject a plan, but not on commercial points. The commercial points are completely with the commercial committee of creditors. The commercial aspects are being only with the solely with the committee of creditors. The adjudicating authority cannot look into the commercial aspects of a resolution plan. It is widely established in various cases. So now, after the approval, assuming the adjudicating authority approves the plan, what happens in such cases? The CIRP is deemed to be completed, and effectively the moratorium will be lifted, and then as per the plan, as per the order passed by the adjudicating authority, the implementation of the resolution plan will start taking effect. That is, it could lead to maybe certain agreements to be entered into, or the handing over of the management to the new management, appointment of a monitoring committee to look into whether the implementation has been effective or not. All these aspects trigger right from approval of the plan by the adjudicating authority. Similarly, on the parallel other stand, if we believe where a COC has rejected a plan, or where COC approved but an adjudicating authority rejected a plan, what happens? It ultimately leads to liquidation. So under liquidation, you need to remember that there are three various, like, what is a liquidation? Before I go further, what is a liquidation? As I stated earlier on the first slide, that is Insolvency 101, liquidation is a situation where the company, there is no resolution possible for the company, or the resolution possible is something which is giving money which is way lesser than the liquidation, that is way lesser than when the assets can be sold on a individual basis. So liquidation is nothing but selling of assets on a basis, selling of the assets of the company on a piecemeal basis. That is what is the basic nature of liquidation. However, the code also introduced liquidation as a going concern. It's a very different topic which I don't want to club in this, but liquidation necessarily means selling of assets on a piecemeal basis. So when what situations can a liquidation order be passed by the adjudicating authority, where a committee of creditors decides that there is no possibility of going forward for a resolution. So that this will usually happen only after preparation of IM, where the committee of creditors forms an opinion that there is no possible value creation in the company. Then the committee of creditors may decide to liquidate the company. Second, so the liquidate the corporate debtor. Second, where there is no resolution plan received till the maximum period of the CIRP. So the committee of creditors waited for the resolution plan. No one is interested in it. No resolution plan has been received. No bid has been received. There is no point extending it, because again, as the code rightly says, either you put the assets to the best use or liquidate. Third is when the adjudicating authority rejects the plan based upon the non-compliance of section 30 subsection 2, the requirements under section 30 subsection 2. In such cases also liquidation can be ordered. So these are the three cases in which a liquidation is ordered. So effectively a CIRP ends either with a successful resolution or with a liquidation. So this is the end of our presentation, the complete points on CIRP. So to quickly summarize, a CIRP process starts. Okay, fine. Before I summarize into it, let me just ask if there are any questions from the participants. Yeah, so we have a question from Ms. Urvashi Shah. Can an adjudicating authority amend the plan? So there was an interesting precedent set forward by the Supreme Court, where the adjudicating authority and also the appellate authority have tweaked the plan in terms of the distribution of funds, and where the Supreme Court has clearly held that there is no way in which an adjudicating authority can amend the plan. An adjudicating authority cannot amend the plan which has been prepared by the COC, which has been prepared by the resolution professional. Do we have any further questions, or can I summarize the presentation? We have we still have Mr. Vikas, Ms. Uvashi, Aditya, Prasanna, and Achyut with us. So in case you don't have any questions, we can actually go forward. What did they say? Can I? Yes, no? ठीक है. Right. Sorry for the interim delay. I'm just creating a small poll to help me understand how I performed in the webinar. So now, before that, I would like to quickly summarize our presentation. So the first and the foremost important aspect. Sorry, before that, we have a. Oh, thank you, Vikas. Sure, because we'll be sharing you the PDF, and also you'll be getting a study material tomorrow morning, wherein I'll be explaining in detail each stage. So that will definitely be there. Thanks for your feedback, Vikas. So before I conclude, as I said, I'll summarize the entire presentation. So the entire CIRP process starts when so the trigger of the CIRP or the IBC is when there is a default. So an occurrence of default attracts initiation of CIRP, and this CIRP can be initiated by either the creditors or the corporate debtor itself, and this creditor can be an operational creditor or a financial creditor. The operational creditor has a separate procedure wherein the financial creditor or a corporate debtor basically file directly with the adjudicating authority the application for initiation of CIRP, whereas an operational creditor cannot directly file with the adjudicating authority. What is the procedure for them then? They have to send a demand notice, an invoice along with the notice, wait for 10 days for the reply from the corporate debtor, where a corporate debtor can either repay you or can rebut, saying that there is an existence of dispute, and where you think there is no existence of dispute, or where there is no repayment received, or where there is no concern raised by the corporate debtor, then the operational creditor may initiate CIRP, in which the corporate debtor may ask as to the corporate debtor may initiate CIRP, and also has to file an affidavit stating that there is no existence of dispute. So now the next part is on the adjudicating authority to decide whether or not to admit this application. What will the adjudicating authority look into? Adjudicating authority cannot look into the intentions behind the applicants in filing this application, because the merits is something which is beyond the scope of the adjudicating authority. The adjudicating authority, even as per the Innovative Industries judgment in the Supreme Court, and also as per various precedents set forward in various other cases, the adjudicating authority cannot look into all other aspects. Only aspect which the adjudicating authority will look into is the condition number 1, whether there is an occurrence of default. And what is the condition number 5? The evidence of default. So condition number 1 and 5 are together. So the evidence will substantiate the occurrence of default, and if these two are there, there is 2 ticks which you have given for the 2 conditions. And second, in terms of application, whether the application is complete or not. Where the application is complete in all respects, which means all the details, minimum details which are required on the application are being given, then the application confirmation is also done. And the next condition is in terms of the IRP, that is the interim resolution professional. I hope through our entire discussion you understand the role of an IRP or a resolution professional, what kind of role they play during a insolvency of a corporate debtor. So now this appointment of IRP, you have to propose the name of the IRP along with your application. So in which case, whether there are any disciplinary proceedings pending against the interim resolution professional is also something which has to be looked into. If there is no such thing, then this condition is also met. So these are the basic conditions for both operational as well as financial creditors. If these are met, the adjudicating authority should not have any ground to say no. However, the adjudicating authority will have, in case of operational creditors, will also look into the affidavit, as I said earlier, that there is no existence of dispute, or rebutting the existence of dispute claimed by the corporate debtor. So this amounts to either admission or rejection of plan. So where all these 5 conditions are met, the adjudicating authority shall admit the application. Sorry, not the plan, but the application. So now that the adjudicating authority approved the application, the CIRP is initiated. So right from the initiation of CIRP, we have gone through various stages: appointment of IRP, and right after the appointment of IRP, invitation of a publication of a public announcement, inviting claims, submission of claims, verification of claims. After verification of claim, constitution of a COC, conducting the first meeting of the COC where the resolution professional is being appointed. After the appointment of resolution professional, appointment of registered valuers, preparation of information memorandum, invitation for expression of interest, invitation of expression of interest followed by submission of expression of interest, and then finalizing the list of resolution applicants, issuing request for resolution plans, evaluation matrix, information memorandum to such resolution applicants, and submission of resolution plans by the resolution applicants, and looking into the compliances whether the resolution application plans are being in accordance with the IBC or not, and subsequently forwarding all such resolution plans to the COC, all the complaint resolution plans to the COC, and then the COC looking into the evaluation matrix, coming forward with the H1 bidder, that is the highest bidder among all, putting that forward for voting, and then either approving it or rejecting it, and then the adjudicating authority's role to further approve the plan and then pass an order, thereby lifting the moratorium and declaring that the insolvency period is done. So this is the entire process which we discussed in the last 2 hours in a crux. I hope this webinar served the purpose, and I really thank every one of you from the bottom of my heart, because the way you have encouraged or the way you have trusted VirtuaLaw is commendable. This is the first webinar of our kind. Even though we have come up with the concept of paid webinars, you did not hesitate to avoid learning through us. So that is really commendable. And as I said earlier, there was a small feedback I would like to know from you, since you have attended all. So I just want you to vote on how you liked the webinar. So this would help us improve our webinar content from the subsequent things. The intention, even though of course I know there are very less number of attendance here, the total enrollments is 15. Of course we limited it to 25 only. So firstly I should tell you that we limited it to 25, and we have received 43 registrations from various professionals, and of which we are of the intention to restrict to 25, but maybe because of certain time constraints other people were not able to attend this. But even the recording of this webinar will be available for the people who can pay and subscribe to the recording. So even that is made available by us. So this Q&A, in case you have any other Q&A at any point of time, that it is still welcome. You have our email IDs, you have the WhatsApp number, so you can come up with your questions at any point, at any time. So we are okay with that, and we would be very happy, more than happy to solve your queries, because it is a mutual learning for us too. And I need to know, at this juncture I need to thank my friends who have been supportive to me, so who are actually helping me whenever a question comes. It's not like I'm just giving you answers right away. So there has been a discussion happening, and they are forwarding me certain suggestions how to respond to the questions. That is how I was able to respond promptly to all the questions asked by you, and I actually would like to thank them. I think with this I can call that the webinar is done, and we will be sending across a feedback form, a Google form, to your email IDs. So kindly take some part of your time to give me a qualitative feedback, not just the rating part, a qualitative feedback as to where I can improve myself, or the areas where you found the presentation was good. So where you think my way of presentation was good, try to comment on that also, so that I can understand that my like my positives as well. At the same time, where I go negative, because when I was teaching in various institutes, there was a comment that there was a feedback that I'm a bit fast in the way I deliver. So that might be my style. So I tried to modulate it. In case you have any other feedback, you are very welcome. And the entire schedule of what other advancements in the IBC I'm going to take in terms of the webinars will be released shortly on our website, will be shared across all of you. Since I all have your contacts, I'll be sharing you what all other webinars which we are planning, which are in the pipeline. So because now that I've set a base for you in terms of the CIRP, the other webinars will carry it forward technically and also in a very intricate manner. Now that I did not cover any intricacy in detail, I have given you a broad aspect of what is happening. So because now I've given you the entire posture of what is happening, now we can question and debate ourselves as to why is it like this and why is it not like the other way around. So yeah, with this I call it a day. Thank you so much again for your patience learning, and yeah, that's it from my side. If you want to know anything else, you may please use the Q&A before I conclude it. And as I said earlier, Mr. Vikas, so you'll get the PDF for sure, the entire infographic, and also a study material, and also a case capsule. Whatever the cases I discussed during the webinar will also be given as a case capsule, wherein I'll be giving a summary of the cases. So I think we can call it a day. Thank you so much. Have a great weekend. Good night.